It's official. If you're using NordVPN, you're using the fastest VPN there is. It means you can secure all of your devices with robust encryption and enjoy blazing fast internet connection without the annoying buffering screen. Built on the incredibly lean architecture of WireGuard, it provides speed like no other protocol. Stay safe with the fastest VPN on the planet.
Hi, everybody. This is Crypto Rich, working with you to get rich with crypto, filling our pockets with crypto profit. And I have with me Peter the Virile. Is that right?
King Peter the Virile. Yes, that's correct.
King Peter the Virile. And what we're actually going to be talking about is not his virility or my virility or the lack of it, because I'm getting on in age, right? We're going to be talking about using the law to preserve and conserve and take back our freedoms that we have lost in the UK, the United States, Canada, Australia, perhaps India and Pakistan as well, because they all from the same legal system. We're going to be going into that. Now, before I introduce him, please subscribe, follow me on Twitter, CryptoRichYT, join my Telegram announcements channel. And if you're watching this on YouTube, do you know what? You're not going to see the whole thing because of YouTube censorship. So you'll find the whole conversation on BitTube and Bitchute. And also, you can also follow me on Lbry and Odyssey, which are all censorship-resistant platforms. Hey, Peter, thank you so much for making yourself available.
Absolutely, it's my pleasure.
Thank you. I discovered your channel through a Telegram group that I'm a member of, all about regaining our freedoms with this lockdown tyranny that's plaguing so-called former Western democracies. And I just really, really like what you were saying about law, because you're a trained barrister and stuff. So I invited you back on. And what we'll do in this first bit, which will go on YouTube, is you just say a little bit about your background. And then we'll just talk about the history of the legal system in Britain or England. And then the rest of it about common law and what we can do and to recover our rights in the lockdown will be on the other channels. Okay?
Excellent stuff.
Good. Now, do you want to start by saying a little bit about yourself and why you're an expert on the law, if at all?
Yes, so my experience with law, I'm currently not practicing as a barrister or solicitor, but I do have a degree in law. I graduated last year, and throughout my degree and before and after, I've had experience in court, following barristers in the courtrooms itself, as well as in chambers, helping with developing cases. So I have a fair bit of experience in law, a few contacts, but the main thing is the educational side. So that isn't just the degree itself, but also reading around outside it, because there's always going to be limits to what they teach you in schools.
Right. Okay. And then what is it you cover? I mean, on your channel, you talk about stuff about the lockdown and everything, and you talk about the laws there, but just to give us a brief overview history of English constitutional law, isn't it? And how that shaped a lot of legal practice all over the world.
Yes, absolutely. Yeah, it's the law of England and Wales is the common law system. So it goes way back till time immemorial. I think that actually is a phrase in law for a specific date. I think 1199 or something. But it goes way back to at least the Norman conquest. And the King's Courts would develop the law in this common law system, which would effectively be them making judgments on each individual case based on the circumstances of the case. So effectively making it up as they go along. And alongside the law, there was the courts of equity, which were the Chancellor's courts rather than the King's courts. So they would have more flexibility in terms of the remedies they could provide. And a lot of the remedies that exist today in civil law actually originated from equity. So that's evolved into sort of a separate concept that runs alongside law. It's where it gets a bit confusing.
Hold on a second, because you've already lost me.
Okay, right? Yes.
Which isn't your fault, but because yours is a very esoteric discipline. So I can picture King's law.
Yes.
Yeah, where I don't know, somebody has some grief or something or grievance, so they lobby the king for an audience with the king, some baron or something, and then the king weighs the arguments for and against, and then they make a judgment.
Effectively, rather than the king, it would be more the judges acting on behalf of the king, or other barons as well on behalf of the king. It would also, we had the system of Aziz's courts, which were travelling courts. So rather than just like a fixed court in a specific place, you'd wait until the court travelled into your town for you to get justice. And that's when all the sort of the criminal cases would wait until the sheriff would sort of hold people. So we had sort of travelling courts, all kinds of big differences historically. If you went to court, you brought your case, and you weren't able to receive any kind of remedy that satisfied your grievance, you then have the option to take it to the Chancery or the Chancellor's Courts of Equity, which was
That's
sort
the
of
bit I didn't understand. The Chancellor's Courts of Equity. Where did they come from, and what are they about?
So effectively, it's that if you go to just a regular court, the judge is fairly limited in terms of what they can do as a remedy. So they can make their decision as to the outcome of a case. But for example, in civil law, they were limited by we can make the defendant pay the claimant compensation, but there isn't really anything else they could do. Now, equity was this system whereby certain if the law wouldn't satisfy a particular grievance, if there was still some kind of manifest injustice and an inequitable outcome, the laws of equity would then have more flexibility. So say for example I don't know, with law of copyright, for instance, where you could compel someone to prevent doing their service, so an injunction. That's a remedy which is now in civil law today, but historically evolved from equity. So equity, in terms of this court system by the Chancellor, was a historical concept, sort of stretching back hundreds of years. Today, the law of equity is slightly different, so it's more of a type of legal interest, and this is where the law on trusts and trustees comes in as well. But I suppose a rough way of explaining it as equity running alongside law would be a house where the title may be in one person's name, but another individual may have an equitable interest in that property. Say, for example, if they were a spouse who lived there for a certain period of time, or there are other circumstances in which they would then have an equitable interest, which the courts can enforce. So even though in law, the deed was signed perfectly according to law and all that, the other individual wouldn't have any legal interest. They'd have an equitable interest in that particular property.
Okay, but where did the Chancellor, where did that position arise from, and how did they get their powers? Because I see where barons and lords and kings get their powers. Where's this Chancellor springing up from?
So the Chancellor was one of the most senior officials in the King's Court, and as the court was, the King was very, very busy with all sorts of affairs. Especially in the times of the Crusades, that sort of thing. The King would always go abroad and fight in various wars. It was left up to the Chancellor to make many of these decisions on law of equity, but equity was more civil law rather than criminal law.
Okay, and then could there be in situations, say in one particular town with the travelling court, you've got the judge passing one particular rule, and then in another part of the country with a very similar issue, you've got another judge giving a different sort of judgment on the same issue?
So that's why we in this country developed the common law system. So that's what the common law system basically is. It goes back to an old Latin phrase of stare decisis, which means let the decision stand. So that's the general principle underpinning it. It basically means the judges make their decisions on a case, and it has to be followed if it's by a court of the same seniority or a more senior court. So say, for example, a high court binds other high courts, and high courts are bound by courts of appeal and the Supreme Court as well. So the common law system developed as a result to provide some consistency, so that the judges had flexibility in terms of being able to decide based on the circumstances of the case. So if there were two different murder cases where there were some similarities, but there were also major differences, the judge would be able to distinguish the two cases from each other if it were right and just to do so. So they had the flexibility, but it also gave the certainty in that if these cases were not indistinguishable, then the same remedy and the same outcome had to be applied.
Okay, good. All right, well, let's go back to the history of constitution of the law in England and Wales.
Yep.
So we've got the Chancellor Courts and we've got the King's Courts, the travelling courts and stuff like that. So then what came next?
So this is sort of way back, sort of certainly pre Civil War here. It was the Civil War when things really started to change around a bit, because all power comes from the Crown legally, and still to this day, all power arises from the Crown. Now, Parliament has ultimate supreme legislative power to pass laws through statute, and also Parliament has the power to remove a monarch as well. So this is where it gets even more confusing, in that in the English Civil War, and
which was when, for the American viewers, and who was involved?
So in the English Civil War, there was Oliver Cromwell, a parliamentarian here, and a big advocate of opposing the monarchy, and he was also a big fan of the banking system. But I'm not going to say any more of that on YouTube. He removed the monarch, or him and the parliamentarians started this huge war where the royalists, so the Cavaliers, had to flee to places like the Isle of Wight and other castles. The parliamentarians stormed in, burned their libraries, destroyed various artifacts. Cromwell actually genocided the Irish as well, but that's another topic. And he melted down the original crown jewels that were minted for, I believe, Henry I. And sort of all the old royal swords and shields and things were all melted down by Cromwell, destructor of our heritage.
Like the Taliban and BLM.
Oh yeah, absolutely. He was basically the BLM of that era, really, and sort of to pull down all the statues, destroy everything. Yeah, the
original Taliban as well.
Absolutely, the Taliban, and he was just absolute iconoclast. He was, it was quite a bloody conflict, and it ended with King Charles I losing his head. And then Cromwell maintained the Commonwealth for a few years, which was a Republican government, but run by supreme dictatorship by Cromwell himself. And at the end of it, eventually the monarchy was restored in the late 16th century. And that was Charles II returned to the throne. Now, that was all well and good for a little while, but a couple of decades later, in 1688, there was the Glorious Revolution, in which King James ascended to the throne. Now, he was Catholic, and Parliament said, we want a Protestant in charge of this country, because Parliament had its ties to the Protestant elite, and that's why, hence, there was, of course, Cromwell's attacks on the Irish as well. But they couldn't have a Catholic in power whatsoever, so they removed him, brought in William of Orange from the Netherlands, and he continued massacring the Irish as well, of course. But he was sort of a big, sort of very bloodthirsty Protestant leader. But he was the new monarch. So the line of the House of Stuart was severed by Parliament, and it also established the precedent that Parliament has the power to remove the monarch and replace them with anyone they choose. Or today they're able to abolish the monarchy entirely if they so please, which is sort of quite a confusing concept, seeing as all of their power comes from the monarch, delegated to them, and they can effectively abolish the crown. But it's a real mess. It is the legal system here, and that's why we need a written constitution. The Constitution of England is known as a living constitution. So and that's just a fancy way of saying it's unwritten. It's various bits and pieces of laws here and there, and constitutional conventions, which are more traditions, but they're not actually binding on Parliament or the monarch. So it's constitutional convention that actually imposes most of the restrictions on the Queen's power. She legally has the ability to dissolve Parliament at any point, yet she's bound by convention not to do so. But I mean, that's how we're at this sort of crossroads where the Queen can dissolve Parliament, but Parliament can also legally abolish the Queen. So it's a real mess, and I think that there is a need at some point. I know there are a lot of advocates for it, but some sort of English constitution would definitely be desirable for these very reasons.
Okay. So then now what we've got this common law system that's evolved, and then you've got Parliament asserting its authority that it can remove the monarch. And then Parliament can then create laws, statute.
Yes. So statutes are laws that are passed by Parliament. They can indeed repeal past statutes, such as many parts of the Magna Carta have actually been repealed today. There are some clauses that are still in effect, such as there's a clause whereby you can't imprison anyone or remove their property without a legal decision, or by a judge or a court. But much of the Magna Carta has been repealed now. And occasionally sort of you hear about common law cases here and there that are overridden by new statutes that would, for example, replace an old definition of a concept. But when Parliament passes a statute, that isn't the law full stop. It's more of a skeleton of the law. So, for example, in the coronavirus regulations, they say you can't be part of a gathering, but it doesn't actually say what a gathering is. There's actually a video on my channel that you can see entitled, I believe, The Caliber of Modern Police, in which I was at an anti-lockdown protest and was speaking to a police sergeant, asking him a few questions. And I was saying, how close do I have to be to this crowd of people to be part of the gathering? And he was sort of trying to waffle his way around it. Well, if you're standing by spectating, then you become part of it. But I mean, you need to go to the courts anyway. The end conclusion he came to was, I can't give you the definition. You'd have to wait for a court to give you an answer, because that's the law as it still exists today. Judges would be bound by past common law decisions when interpreting current legislation. and they can, of course, also make up their own mind in how to interpret it. There's a lot of power in the hands of judges. There's a concept known as the persuasive approach, not persuasive, sorry, purposive approach, which is basically a concept whereby judges are able, rather than reading the exact wording of a statute and saying, we'll follow this down to the letter, they can interpret what they believe Parliament's purpose was when passing the statute. So it enables them to get around specific wording. So even though Parliament has the power to effectively overturn common law, it still is very much limited and curtailed by the judges and how they interpret it. So their power isn't completely ultimate, as it is often made out to be.
Right. And then the judges are, I suppose, operating from this legacy of common law decisions that have been passed down to them and that form the foundations of the judiciary.
Effectively, yes, that's precisely it. I mean, the judges' powers go back, as far back as Britain, England and Wales exist as a united kingdom. Basically, it goes back as far as certainly pre-Norman conquest. It's this legacy of a judicial system which has evolved over so many years and still is the backbone of our system. And as a result of the British Empire and the Commonwealth, it's the backbone to many legal systems in other Commonwealth countries as well. For example, Australia, Canada, the United States. I believe India also has some of a common law system as well, and it's a large part of the legacy.
South Africa.
Yes, South Africa, Pakistan. So it's what the common law system basically means that the judges have more power, and a lot of it comes from England and Wales. Old English and Welsh common law pre-colonial times is not necessarily binding on judges in other jurisdictions. It would be what's called persuasive precedent. So even in domestic decisions, the only part of a decision, the actual judge's decision that's binding, is what's known as the ratio decidendi, which is the reason for deciding. So just the reasoning they gave for reaching their decision in a case. Any other comments they make that are relevant to the legislation wouldn't be binding on future judges. That would be persuasive common law. It's known as obiter dicta, other things said in the case that judges can take into account if they so choose. Other Old English and Welsh common law in other jurisdictions would be persuasive precedent, so judges can choose them if they follow. Likewise, decisions from other jurisdictions can also be persuasive precedent in the UK as well. Several Australian cases are still cited in courts today as persuasive precedent. And it also applies to the Privy Council. So Privy Council decisions, whilst binding on certain Commonwealth countries, are persuasive precedent in the United Kingdom.
Okay, now what's the Privy Council?
So the Privy Council is effectively the top court for many Commonwealth countries. So they can appeal up through their own national courts, and then they can reach a final decision from the Privy Council at the very top.
And who gives the Privy Council their powers? Does the Queen appoint them, or Parliament, or do they rise up to the judiciary?
In terms of how they actually get their roles, they come from a variety of places. Some of them are appointed, some of them do rise up, but all of their power, like with all of the courts, is from the source of the Queen. The Crown is the source of all of that legislative power.
Okay, it's quite an interconnected web with power going in both directions. So Parliament can remove the Queen can dissolve Parliament can issue laws that tell the judges what to do, but the judges can then reshape those laws that Parliament issues according to how they interpret it.
Exactly that. It's not simple. They make it as confusing as possible, but it's because of the way our legal system has developed so uniquely. A lot of other countries, you look at, for example, America, they gained their independence from the United Kingdom, and they then had their constitution, which outlined all of the power structures and everything. It's very black and white there on the page. Whereas the UK system, as we don't have a written constitution, it's very much up in the air. And I think legally, with the current power structure, it's effectively impossible to have a written constitution, because Parliament has ultimate power. They can, as I mentioned, they can make any law they so choose, and they can also remove any law they so choose. There was a big 19th century legal theorist called A.V. Dicey, who sort of is one of the main sources that people use today when talking about the outline of the power structures of Parliament. And he described parliamentary sovereignty as them having the ability to make any law, no matter what the law is, even if it's against international law. Parliament can still pass that as domestic law, and it would still be enforceable by the courts. The only real limit to Parliament's power is they can't pass a law that would bind future parliaments. So they can't say, here's a constitution, no one else can repeal it in the future, because that would be limiting the power of future parliaments to make the laws as they so choose. So with the current system we have here, it would be practically impossible at the moment, unless there's sort of major structural change to the system, to have a written constitution.
Right. Okay. But then there are certain laws, like natural law or maritime law, and here we'll continue this conversation on the other platforms. So anybody who's watching, and if you're not already subscribed to me on BitTube or Bitchute, or follow the links in the description below, and you're going to get the rest of this conversation.